Okay. Thank you all for tuning in. It's just me today. Heather has a board meeting for Norbar on the third Friday or whatever it is of each month. And so she won't be here, but next week she will be doing the full session because I'll be out of town. And she'll be doing a deep dive into one of our technology tools. She mentioned maybe the CMA, maybe IO docket disclosures, but she'll spend the 45 minutes or so on a deep dive into one of our technology tools, and we'll let you know ahead of time which tool it is. So if you're interested, you can check in. We are in an early rollout for the Better Homes and Gardens rollout of MoxieWorks. MoxieWorks is the state-of-the-art software, agent support software. So that will be coming in the next couple of months. So she'll be doing training on that as we move forward, and it becomes available to us. So that'll be great. She's also got 100 Days to Greatness training coming up in mid-August, which is a Brian Buffini program. I think it lasts 14 weeks, one meeting a week with kind of homework in between. And for newer agents or agents who want to kind of get a kick on their production, that would be good to put on your calendar to attend. She's got her certification as a Buffini moderator, and that she'll be able to teach that course. So before I start with my collection for the day, anybody got a contract or transaction issue to discuss? Questions? No? Okay. So a couple things came up this week. Just got off the phone with one of our agents, and they were in escrow on a 7-day close, which sounded all good and well. The buyer had made 4 offers on previous properties. They made this offer with a very quick close. They were ready to go. And they got the prelim. It had to do the death. The owner had died. Everyone had thought that the property was in the owner's trust, surviving trust, but it turns out the attorney, God bless attorneys, never filed the papers to get it into the trust. So it needs to go through probate. And anyone had something go through probate and can tell me how long that should take? No. Well, I'm told it's probably a 60-day process. So now that the buyer was all ready to close and the sellers are all ready to close, the heirs, in 7 days, we've got to write an amendment to the contract saying it's going to be 60 days. And the buyer actually received a credit from the seller for that extension. And then there's a second provision in the amendment to the contract that says if it's not closed in the 60 days, it'll be extended another 30 days with an additional credit to the buyer for that extension. And if it doesn't close in that 90 days, then the buyer has the right to either continue in the contract or cancel. So that's kind of how that's done. Now, the thing I particularly want to share about that is the agent called me and said, I'm writing up an addendum. And, he read off the terms of the addendum and it all sounds fine. The only thing is, remember now we use an amendment form if we're changing the terms and conditions of an existing agreement. So you're in contract, let's say you put in your RR, you got the seller to accept the RR, you're going to write a change that says, seller to credit buyer such and such amount. $5,000 or the price to be adjusted to, $900,000. That gets written up then in an amendment of the existing agreement terms form, this one, AEA, and not an addendum. The addendum we use for the initial, if you're writing an initial offer, then the addendum form gets used as adding additional terms. But if you're amending the existing agreement, whether it's a listing or a contract, you use the amendment. Okay. Next, we have a buyer who has removed all contingencies on the property. It's governed by an HOA. So there's like 177 units in this HOA. And the buyer removed all contingencies. They were due to close last week, but we found out the HOA insurance had lapsed. So, the HOA has a master policy covering those things that the HOA is responsible for. There's certainly a general liability property in case anyone gets hurt in the common areas, which is very important. But also, in the case of where I live, Sonoma Greens, the HOA is responsible for the structures. If a building were to burn down, they have to rebuild the structure. So having the insurance lapse is not a good thing. So the buyer wanted to cancel. He didn't want to move into the HOA without, the place without having the HOA have insurance. And our agent doesn't know why the insurance has lapsed or why the HOA isn't getting it. She's not getting straight answers from the people responsible for that. So it's kind of in limbo. Because my point was, I could go out and get insurance tomorrow. I just call the agent and say, insure my house. HOA is obviously more complicated, but for whatever reason, this is dragged out for some period of time, a month or so, that the HOA hasn't renewed their insurance or gotten new insurance. So we determined the buyer probably had the right to cancel because it was a new disclosure item that the seller made to the buyer that, oh, by the way, the HOA doesn't have any insurance. And that's what happened. So unfortunately for our agent, the buyer pulled out of that transaction. So sell them another home, we hope. But those are some of the things that lead to my use of the Shakespeare quote that many's the slip twixt the cup and the lip. So picture the guy walking around with a cup of wine and trips over something and it spills out. And that's kind of what happens in our transactions sometimes. So be prepared. Another thing that came in was a transaction was put together with a SIP, SIP, the seller in possession form. So the seller was going to occupy the property after close of escrow for 30 days. Remember, if it's 30 days or less, you use the SIP form. If it's 30 days or longer, you use the residential lease. So now they found out that the seller is going to be out early and the buyers can take possession at the close of escrow instead of having to have this SIP. So the question is, do I need to submit an addendum stating the SIP no longer applies and that the buyers are to take possession at close of escrow? And yes, the answer is, except it's not going to be an addendum, it's going to be an amendment, as we talked about before. So that's easy to take a provision out of the contract if it's no longer applicable. So, but we got to do it in writing. Everything in real estate, as they say, has to be in writing. This question came in. This was a note to our agent. Sally and Fred would like to sell 50% of their interest in West Agua Caliente property to Johnny. The sales price will be $333,750. The sellers will carry a note. Can you let us know the process steps needed to do this and what your broker would charge to do this? So the agent wrote and said, can we do a 50% sale? I've never sold a partial interest, so before not know how to proceed, can you please give some guidance? So, yeah, certainly an owner can sell a partial interest in the property they own, but they're going to have to set it up in a structure that allows them to sell it. So that would either typically be tenants in common or joint tenancy. And remember the distinction when you were doing your licensing practice preparation, there's a distinction between joint tenancy and tenancy in common. And I can't tell you what it is off the top of my head because it's a legal matter and, you know, we don't practice law. So they need that person wanting to sell needs to contact a qualified California real estate attorney and get the structure prepared. I guess you could do it in an LLC or a partnership agreement also. But whatever the legal counsel recommends and they decide to do, they need to get that set up. And then certainly they can convey a 50% interest. In terms of what we charge, you know, that's a discussion, you know, I have with you when you are going to reduce the standard commission below our you know, our 6% threshold or 5% if we exceed, you know, $500,000 is kind of where the market is. So if the agent, you as an agent are going to be reducing the commission below that, you'd want to discuss that and get my approval and or Randy's approval for that before moving ahead. So we didn't get that far because we're going to take the other steps first. But we certainly can do the paperwork on that sort of thing, and it's quite possible. Any questions on that? Okay. Okay, so here the buyer and our agent representing the buyer are preparing an offer on a property that's already had a home inspection and a pest report. And the clients have identified that they want what they want repaired and a credit for the rest. Can I submit the offer with a request for repairs and request for a credit and remove inspection contingency at the same time? First, let's address using the seller's reports. Eric, you want to give us an update on that situation?
What situation, Gary?
Wake up, Eric. Using the reports provided by the seller.
Well, in general, it's probably prudent advice for the buyers to get their own inspections and not rely on the inspections provided by the seller, because unless you know the inspector and it's a reputable company, they may not be reliable.
And what is the end result of that in the circumstances that actually occurred?
Not sure where you're going with that, Gary.
Well, if my memory serves, you once had a client who bought a home and we relied upon the seller's pest report. And after they moved in, some either dry rot or an infestation was discovered. And the buyer let us know about it and said, hey, this wasn't covered in that report. And again, my recollection is, okay, well, let's call the pest inspector and see what they're going to do about it. Because they missed it in the report, they should come back and take care of it. And do you recall what the pest company told us?
Well, I'm not sure what we're talking about, but the only example I can think of, Martin Rodriguez came and fixed it.
Okay. Well, the one I'm referring to, the pest inspector said to us, well, you aren't my client. I got this for the seller. I did this report for the seller. So I have no liability to you because you aren't my client and I'm not going to do anything.
Was this a Creekside property?
It's coming back.
Did it involve rats?
I'm not quite sure.
Because otherwise, I'm not sure we're talking that you've got the right agent.
Okay, maybe not. But my recollection, again, is you and the company ponied up some money to make the buyer happy because no one else would take care of it, and it got taken care of. And
That was definitely not me. You got me mixed up with somebody else. I have never gone out of pocket except once, which was just to get rid of some attorney that was filing a frivolous lawsuit.
Okay, all right. My mistake, but I knew you had experience in the area. I remember, Eric, we've worked together some probably 30 years now, late 1990s. And when we were stationed out in Glen Ellen, when I first came up here, and we were out in Glen Ellen, and it was Eric and Catherine Moylan, and a couple of other agents, and most of you won't, well, some of you will recognize, but anyway, and Dean Crumley was our office manager. And, there was just kind of things going on, and it was, this isn't working right, this isn't working. And so I had a sign made up. We had called ourselves the Wine Country Group, but I made a sign up that said wine, WHINE Country Group. So, and that hung in the lobby for a while.
I remember that well.
But anyway, the short of it is that yes, we should advise the buyer not necessarily to rely upon the seller's reports, because we won't have any recourse against those inspectors, that home inspector or the pest inspector, if they miss something that's not covered in the report. So always encourage them to get their own reports, and they can make that decision on their own. But we should be clear that we encourage you to, and the inspection advisory, and there's various places it's covered in the contract and the inspection advisory and so forth. But we should also make an explicit email written statement to them. You should certainly review these reports and consider getting your own reports. Now back to this. So the buyer was willing to accept the reports, and that was taken care of. So the question became, do I write that up in the offer with an RR, attach an RR to the offer? Well, in my view, the RR is a form that's going to require the seller's response. So it adds a layer to the contract that's not necessary, because ideally you want the seller to accept the contract the way you've written it. So my suggestion was just write those terms, that credit or the repairs to be done in the contract in an addendum. Then in that case, we would use a regular addendum. And in your cover letter to the listing agent, say we're writing the contract with these terms because we review the reports and the items 1A and 2A and in paragraph blank blank of the report called for these things needed to be done. So that way they can just accept the contract as is without having to do a counter offer and so forth. And removing contingencies on making your offer, that's also risky. And we've talked a few weeks in a row about the distinction between having investigations and having inspections. And remember, if you go to, let's see, we'll go to this contingency release form, contingency removal. We have this option down here under 2A, 3A, 2A, 3A, that the buyer's investment contingency, only the following individuals checked by the buyer's contingency are removed. And this says only the physical inspection portion of the buyer investigation. So that's preferable to removing entire investigation contingency, whereby the buyer doesn't have any investigation rights regarding other things about the property. So we made it, I was representing a buyer recently, and we made it subject to removing the physical inspection because they were satisfied with that. Yeah.
Hey, Gary, a clarification there,
There what?
question,
Yes,
a question.
yes.
If you remove your physical inspections, are you then no longer able to get a pest inspection? Or
No.
would that technically be an investigation?
It would
Because it is a
technically,
physical inspection,
right,
but it's also an investigation.
true. You could do, reports, you could do a home inspection or a pest inspection, even though you've removed your physical inspection contingency. It just means you can't come back and say, oh, because of this report, this pest report, I want a $5,000 credit. Because you removed your physical inspections. Now, you could ask for a $5,000 credit under your investigation rights and not give a reason for it. So they say, why do you want the $5,000 credit? We said, well, we aren't going to buy the property unless you give it to us. That would fall under the investigation clause. Okay. So you really have it's almost like having a double dip if you really wanted to have that. You can remove the physical inspections, but still do physical inspections. Okay.
And so we're calling a pest inspection a physical inspection.
Yes. But it doesn't mean you can't do the physical inspection. You just can't use it as a contingency. Get the distinction? Let's go back
Okay.
and, yeah, let's go back and look at that.
Yes.
Yes. Let's just one more time, go back and look at paragraph 12. We usually get, kind of all worked up about paragraph 14, which is in the inspection periods and all. But this, let's see, where's my scroll bar here? It's paragraph 12 that is really the controlling paragraph here. Okay. All right, buyer's investigation of property and matters affecting the property. Buyer's acceptance of the condition of and other matters affecting the property is a contingency of this agreement as specified in this paragraph and paragraph 14B. Within the time specified in 14B1, buyer shall have the right at buyer's expense unless otherwise agreed to conduct inspections, investigations, tests, surveys, and other studies. Buyer investigations called collectively, including but not limited to, and then it goes through all these things. So, you know, investigations, if you remove your inspection contingency, you still have your investigations, tests, surveys, and other studies. So in my mind, that would include whatever you want to do, you know, additional stuff. I think you could remove, if you have existing reports and you're relatively happy with them, you could remove your inspection contingency, but continue on and do other investigations. I have a.
But if you removed condition 12A, you've removed everything relative to that.
Right, you have no out on any matter. No, you're kind of going to buy the property unless the seller gives you a new disclosure of some sort. There's a situation now that where pest report and a home inspection done by the seller, the buyer had a contractor come out and go around the house for 3 hours with the documents in hand, look at all the items that were pointed out by those inspectors. And there's quite a bit of stuff, replace the electrical system, repair dry rot under the house from water damage, water barrier, all kinds of stuff. So, it's totaling over hundreds of thousands of dollars. So the question then, the buyer originally said, well, I'm going to get my own inspections. But now, since they're going to have so much work to do anyway, what's the point of getting their own inspections? They're going to basically tear the place apart. So now they're deciding not to get their own inspections, but just to ask for substantial credit based on the seller's own inspections. And to further that negotiation, when when we're going to go back to the listing agent and say, okay, we're asking for all this stuff based on your reports, it's important that you have something in writing from a third party. So the the contractor who looked it up made these estimates is going to write a report, and then we'll submit that along with the request for repairs. So we'll see how it goes. Let's see. Oh, the last one. This week's weekly practice tip was based on the death on the property and the disclosure requirements. California law about that. Buyer concerns either due to cultural or personal issues. Some buyers or tenants will not want a property where a death has occurred, blah, 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 blah. There's if a death has occurred on the property within 3 years, it's mandatory for the seller or landlord to disclose that. There's the reference to notorious events, murder on the property or something like that. So look this over. There's 7 practice tips here. So it's lengthy. I don't want to cover it here so much, but that was last week's practice tip. If you need another copy, just let me know, but it was in the email I sent out on Tuesday. Okay. Unless there's any questions, we can get out of class early.
Gary, I had a question.
Okay,
When you were talking about Sonoma Greens as an example, using it for who had the insurance policy on the structure,
yes,
I think you said that the HOA had the insurance policy on the structure, which means it's a condominium, not a PUD. Am I correct?
no, I think the definition of condominium and PUD has more to do with the type of the buildings they are.
My memory, and this is why I bring it up, my memory was in a condo, you own the airspace, the PUD owns the structure. I'm sorry, the association owns the structure. And
Right.
in a PUD, you own the structure, therefore you would have your own insurance. So
True.
you're probably not a PUD, you're probably a condominium, if what I'm remembering is correct.
No, because we do own the land under the property, and we do own the building. In fact, we're responsible for certain exterior portions of the building, like the decks and railings.
So you are indeed a PUD.
Yes, yes. The Greens is a PUD. Yes, I think the distinction between the condo and
But
the
then you
PUD
own the structure.
well, the homeowners association is responsible for the exterior of the buildings and the roof, you know. So I'm sure if there were a fire and one of them burned down, it would be combination of the homeowners insurance, you know, the HOA policy and the homeowners policy that would get the place rebuilt. Because different policies are, you know, different parties are responsible for different parts of the construction.
Okay,
By the way, that reminds me, there was something pointed out the other day that I think Bayris added the category PUD now. And if you've set your hot sheet up for by specific types, and you don't have like all residential, and you set up single family homes, condominiums, you know, this so forth, you'd have to go back and reset your hot sheet to include PUDs, because people were finding that they weren't getting notices in their hot sheet of new PUD listings because their original hot sheets in the MLS didn't have that checked off. So that's just something to check. If you have your own hot sheet, just check and make sure you get everything you're looking for. Okay. Curtis put something in the chat. Let me just see, but it still comes down to the HOA docs. Yes, it's very confusing. Yes, it is, Curtis. Thank you. Yeah, different HOA docs are, you know, have different provisions. So rebuilding after fires, it would be very complicated, I'm sure. Okay, if there's no other questions, have a great weekend and carry on. And we'll send you a notice. We will have, we're going to move our sales and marketing meetings to Fridays at 10. We'll continue this training, contract and ZipForm training at 11. So that gives you a block, a period you can block out from 10 to 12 on Fridays, and then go play hooky, if that's what you want to do. Or go sell a house. I'll say that.
Sell a few, yeah.
Okay.
All right. Thank you, Gary.
Okay, everybody.
Okay,
Have a
enjoy
great
the weekend.
Talk later. Bye.
Bye.